Members of the Judicial Committee, for giving me the opportunity to speak tonight in support of H7753. I'm a licensed psychologist practicing in Rhode Island and Massachusetts for the last 16 years my specialty has been adult survivors of childhood sexual abuse, with a particular focus on clergy abuse. Since 2002, I've been a sexual abuse survivor advocate and a spokesperson testifying to change the perpetrator-friendly laws, particularly in Massachusetts, and speaking at conferences and to the press, also running survivor groups. But my last and best credential, as Carol just mentioned to you, is that, for testifying before you, is that I was sexually abused between the ages of 5 and 12 by our parish priest in West Warwick. I totally repressed my memory of abuse until I was 40. At that time, my 3 children were about the age I was when it began. And I brought a picture of myself as a kindergartner because we sit here as accomplished adults and look, and you don't realize what the damage is being done to a child. This is what I look like in kindergarten. Sexual abuse crimes are the only crimes I know that leave the victims in a profound sense of shame. That's true if you're 5, abused by a trusted adult or family member, or if you're 35, raped by a stranger. That deep shame is the reason the statute of limitations needs to change. That shame keeps children from telling their parents and sometimes telling themselves. It keeps people from admitting that it happened or that it had an effect for years, or more commonly for decades. I'll be specifically addressing childhood abuse because that's my expertise. Most of the people who walk through my office door to work on their childhood abuse issues for the first time are in their late 30s. They're all the way to their 60s and 70s. I get calls as a volunteer from people as old as their mid-80s telling me their story for the very first time. My repressed memories were clear-cut and total, but most abuse victims have some memory of the abuse, but they've tucked it away in the back of their minds. They may experience many of the symptoms of sexual abuse. Their lives can be a mess. They have PTSD symptoms, but they don't identify them as that. They never attribute it to the abuse. Until one day, they see something in the newspaper about a college coach like Sandusky, or they look at the innocence on their child's face, or they watch a movie like Spotlight, and suddenly the floodgates open. I never filed a lawsuit when I first started to work on my abuse issues. At the time when my statute of limitation clock started ticking, I was in no emotional state to bring a lawsuit forward. I wasn't ready at the 3-year mark I had then, or at the 7-year mark I might have now. In fact, during most of that decade, the 1990s, I was in therapy 2 or 3 times a week, working desperately on my feelings and trying to keep my head above water. I was a mother, a wife, and a therapist, and I was trying to do all that and deal with these emotions at the same time. The people I know who brought forward lawsuits at that time when I could have filed, it took them 11 years to resolve their suits. I would have had to have been hospitalized. It would have put me under for sure. Today, I could handle the rigors of a lawsuit. It's 25 years since I recalled it, and 53 years since the abuse stopped. That's a long time, but now I could do it. Maybe I could have done it 10 years ago, but remember, I had more therapy than most people and an incredibly supportive family. Many of you are lawyers. I don't have to tell you how difficult the clause in the current law about the time since the victim discovered or reasonably should have discovered that the injury or condition was caused by the act. It's really hard to defend legally. When a case is being brought against someone with very deep pockets and a 2,000-year history of protecting its own, it's easy for their legal team to use this clause to throw a case out of court. It's a nearly impossible hoop that for abuse victims to jump through. You might ask, why change the civil laws? Aren't they just about money? The answer is absolutely no. For most abuse victims, it's the only chance for obtaining any justice, for making their perpetrators face some ramifications of their actions and their protectors accountable. It is a way to name the perpetrator publicly and ensure better protection for the children who are around him or her. As you probably know, sexual abuse is very hard to prove criminally. There are usually only two people in the room, and one is at an extreme disadvantage. There's rarely physical evidence, especially for childhood abuse. I can't tell you how many times I've heard stories of children throwing their underwear in the dumpster on their way home from being abused. There is no physical evidence. The burden of proof can be far too rigorous for a victim to do a criminal case. But make no mistake, the process of taking a perpetrator or an organization who enabled them or protected them to court, even civilly, is grueling and deeply triggering to abuse survivors. I have the deepest respect for all those who attempt it. The current laws keep perpetrators anonymous, free to victimize others. It allows churches, schools, summer camps, and more to continue business as usual, protecting their reputations at the expense of children's lives. Bringing sexual predators to any form of justice always has the effect of protecting children. That's why I'm here today, not for myself, but for the children about to be hurt and forever changed by this horrible crime. Thank you.
Thank you, Ann. Are there any questions? Yes, Representative Roberts.
I don't have any questions, but I just want to commend you for coming forward to tell that story, because I know that is difficult. And the thing is, you look like you're doing great, but not every victim turns out like that. There's always some kind of residual consequence. So I was under the impression that this type of bill had already been put forward before in the statute of limitations. They no longer had that. So you're, okay, so obviously you put this bill forward, so that wasn't true. So, but
Currently there isn't, right?
I'm sorry?
Currently, it's 7 years, and it's...
Oh, it is?
7 years from the time of the injury or 7 years from the date of discovery. So you knew or should have known.
Okay.
For
For
civil only, civil
For
only.
criminal, there is no statute of
Yep,
limitations.
okay.
Right.
All right. Anyway.
But criminal is so hard to prove that
Yes.
most abuse victims have to go the civil route to get any justice at all.
Yes, very difficult, and the law absolutely protects the criminal.
Right.
So perhaps there's more we can do for that. Thank you. That's all. Thank you.